What I want to do now is talk in much more detail about parliamentary sovereignty. What I'm going to do in order to elaborate this argument is make reference to one of the major writers on the British Constitution, Albert Venn Dicey. Dicey from here on in. Now, Dicey, in his major work on the British Constitution, said or described parliamentary sovereignty through three rules, which I'm going to outline to you now. So, firstly, Parliament is the supreme lawmaking body and may enact laws on any subject matter. Secondly, no Parliament may be bound by a predecessor or bind a successor. Thirdly, no person or body, including a court of law, may question the validity of Parliament's enactments. Okay, let's just think about these rules as a block of three, and then I want to say a little bit more about them. The three rules, Dicey's three rules of parliamentary sovereignty, clearly follow from the idea that Parliament is the supreme lawmaking body in the British Constitution. That everything Dicey says really follows from that fundamental fact. So let's just try and work through what this might mean. One of the problems, and I'm sure this may even be a problem to a listener of this lecture or somebody thinking about these things. Parliament sounds tyrannical. It can change any law that it likes, and there's no body that can stop it. Now, that's the real problem here. Now, I'm going to give a number of answers to this question. Sir Leslie Phillips, another commentator on the Constitution, I think gave us a particularly pointed way of thinking this problem through, thinking this question through. He said, could Parliament pass a law condemning all blue-eyed babies to death? Clearly a very emotive, striking way of putting it. And the answer that Phillips comes up with, and this comes back to Dicey, and I think it's probably still generally true of the contemporary doctrine of parliamentary sovereignty, is both yes and no. It might shock you in some ways, but let me try and elaborate what I mean here. Now, clearly, if we are saying that Parliament is sovereign, and Parliament can change any law that it likes, and that there is no body that can overrule Parliament, then it would certainly follow from that Parliament can make a law murdering blue-eyed babies or depriving a particular section of the population of their property. Any of these things which would strike us as horrific. Will Parliament do this? Now, this is a different question, isn't it? The answer is hopefully no. Or at least that's what some people would say the answer is. Parliament wouldn't do this because of the realities of politics. Can one imagine, for instance, a government that suddenly passes a law, which it can do, saying that if you are blue-eyed, you will be sentenced to death? Well, it seems fairly unimaginable, doesn't it? Why is that? Well, it could be because, for the most part, at least it's possible to argue, that the last civil war in the United Kingdom was in the 1600s. In other words, we have a country characterised by an extended period of peace where certain political bodies have not done, again, one has to be careful with these things, have not committed acts of genocide or acts of civil war. So this may reflect really just an understanding of the political settlement in the United Kingdom and the relative political social peace that has characterised the last few centuries in the United Kingdom, at least in mainland United Kingdom. So the issue that we have to work through here is the distinction, if you like, between legal and political sovereignty. What do I mean by this? Well, if we're thinking technically, i.e. can Parliament make or change any law that it likes? Well, what we are referring to there is legal sovereignty. Parliament legally has that power because it is the sovereign body. However, we need to make a distinction between that legal sovereignty and political sovereignty. We could say, as far as the political sovereignty of Parliament is concerned, it is limited. It is limited by the democratic accountability of Parliament to the people. Parliament is not then politically absolute. Parliament, as I've stressed, owes the government that has power in Parliament owes the fact that it is in Parliament to the fact that it's been voted in to Parliament. In other words, it's politically limited throughout the period of a government, the time that government is in power. It can do what it likes, but it is ultimately accountable to the people when there is a general election. In other words, Dicey and any sensible commentator on the Constitution has to make a distinction between political and legal sovereignty. Legally, Parliament can make or unmake any law that it likes. Politically, Parliament is limited. It's limited by its accountability to the people and also perhaps to the general rules, practices, conventions and understandings that have themselves grown up in British politics, and also, I suppose, by the politically possible. For instance, one could imagine that the present coalition government could, in principle, make a law about abolishing cars, abolishing private ownership of cars, let's say. Would it do that? Well, it'd be politically suicidal to do that. It would be the end of that government, certainly in the medium term, if not in the short term. So, once again, this seems to draw our attention to this distinction between legal and political sovereignty. Could a parliament legally pass an act of parliament, create a statute that abolishes private ownership of motor vehicles? Well, yes, it could. Politically, would it do that? Well, probably not. And that seems to me to give us a fairly good understanding of the dynamic of parliamentary sovereignty. Let me just pick up a number of other points about parliamentary sovereignty in relation to Dicey's three rules. Dicey says that no parliament may be bound by a predecessor or bind a successor. This would mean, for instance, that no parliament can create an act that is binding on a future parliament, and no parliament is compelled to follow an act laid down by an earlier parliament. So in terms of the strict legal theory here, we could say that this is the continuing theory of parliamentary sovereignty. It's a rather technical term. It's explained by Ian Loveland in terms of the idea that, if you like, in terms of the theory of it, the continuing theory maintains that the sovereign parliament is a perpetual institution. Its unconfined legislative power is created anew every time it meets, irrespective of what previous parliaments have enacted. So that's the idea of the continuing power of Parliament. Now, it causes us to reflect in some ways on referendums and things like that. In other words, is a referendum passed by one Parliament binding on a subsequent Parliament? Legally, probably not. Politically, well, it takes us back to that whole old story, doesn't it? Would a Parliament be bound by a referendum passed by an earlier Parliament? Well, legally, that later Parliament can change its mind. It's not bound by that referendum. Whether or not politically the governing party would want to do that is, of course, another question. Dicey's third rule that relates to parliamentary sovereignty. And that is the idea that no body, no court effectively, may question the validity of Parliament's enactments. In other words, no British court has the power to strike down an act of Parliament. Obviously, if one looks at other supreme courts in other jurisdictions, one might come across this power. In other words, the power to declare that an act is null or void by reference to the Constitution. That is not the case in the United Kingdom. Although we have a Supreme Court, it is not in this sense supreme because, as I've said, Parliament is supreme. So courts cannot question, cannot strike down, declare void acts of Parliament. That would be, if you like, a constitutional revolution. I'll come back to this point because it takes us to one of the main themes that certainly are appearing in contemporary law and contemporary politics about the relationship between judges, human rights and Parliament. Certainly a theme that needs to be thought about in the wake of the Human Rights Act, but this is a theme that we will come back to presently.